Welcome to Dementia-Friendly Prince George's County, Maryland, Northern Sector webinar series for caregivers. Today's topic is Taking Charge of Your Legacy, sponsored by Prince George's County Government and the Department of Family Services.
And thank you so much for attending tonight on this very hot summer night. I appreciate your time, and my goal is to basically just give you some insight of how you can take charge of your legacy. So what does that mean exactly? I just want to see, convey to you ways in which you can think about how to preserve what you've worked hard for to the maximum extent, and to protect it, for beneficiaries that you have in mind, and for yourself. Okay, next slide. Who needs an estate plan? Well, I believe everybody does, whether you're on the younger side or you're later in life. Everyone can benefit from an estate plan. And an estate plan is something that is more or less 3 documents. Some people will tell you maybe there's 4 or 5. I like to keep things simple. I like to have 3 documents. Next. So I'm going to talk about what the documents are as we go along, but one of the purposes of planning is to have the say in who and what. So what does that mean? It's who you're choosing to act on your behalf if you need someone to help you during lifetime, and also to choose someone who's going to take care of details when you're gone. The what is, well, what are your assets? What are we trying to protect here? One of the purposes of planning is also to minimize conflicts. If we don't say who and what, then family might very well argue about it during lifetime and afterwards. And part of the bonuses of getting your plan together now is you might discover, oh, I have something over here that I completely forgot about. So you're going to inventory your assets, not in a, doesn't have to be super detailed way, but it's going to get you thinking about what you have. Do you have life insurance policies? Do you have investment accounts, checking, savings? Maybe you have too many checking and savings accounts opened. So it's going to give you a sense of what you have and maybe how you can organize it. Next. So what happens if you do not plan? Well, the probate court is going to decide. So built into the laws of Maryland by the legislator is what happens to people's assets if there's no will in place, the last will and testament that would say where your assets should go. Some people might be surprised that in Maryland, like if you're married, for example, all of your assets are not just going to simply pass to your spouse. They will if you have those bank accounts or house or houses titled together, both your names are on it. But if you have an asset with only your name on it, it could very well be split between your spouse, and your adult children. And perhaps that's not what you want. So you don't want the legislator to decide what happens to the money you've worked hard on saving and accruing over the years. And you don't want a probate judge to decide how the assets are distributed or who's going to be in charge of that distribution. You want to determine who's going to be the person who's going to handle everything for you. You also don't want assets to end up with unexpected people. That can happen. I've seen very strange things happen. I've seen money that was meant for an adult son go to a friend. So there are very good estate planning will cover all the loopholes and put it in a way that you'll have a plan, you'll know exactly where everything is going to go. Planning also helps with family disputes. You want to try and avoid disputes to the extent possible. Also, if there's no plan in place and you go to probate court, you lose your privacy. The process becomes a public record. Now, if you have minor children, then also the estate plan is going to choose who would be the guardian. Next. Okay, what assets do not go through probate? So again, and just in case there's a little bit of confusion about what probate is. Probate is a court process that is going to oversee the distribution of your assets on death. Okay, there are certain assets that go through probate. There are ways to avoid probate, and then there's assets that just don't go through probate at all. So if there is something that is held with a right of survivorship, a house, for example, between a married couple, husband's portion of the home will pass to wife. Or maybe there's a brother and sister that has a house with a right of survivorship, then the house would pass automatically to the other sibling. Life estate deeds are a great way to avoid putting the house through probate without having going to the extent of a trust. Now, if you do have a trust and the assets are owned by the trust, then that avoids probate as well. Also, assets with a beneficiary designation. So, what does that mean? If you've got a checking account, a savings account, an IRA, a 401k, etc., you should have been given a beneficiary designation form. It's possible that you were not. So if you haven't checked in a while, you're not sure who is the beneficiary on your account, you should definitely check, okay? Because those are pay on death accounts. So what that means is no matter what your will says, okay, if you've got a beneficiary in place on that account, the money is going to go straight to them. It's going to pass probate. It's not going to stop. It's going to go directly to the individual. Next. Okay, so what does an estate plan do? It does a number of things. Now, I mentioned in the beginning there's 3 documents. So I like to use just 3 documents. I think it's simple. If you've got a more complex estate, then we can add more. But it really depends on a person's situation. So at the most basic, the first document is a will. It's the last will and testament. It's the document where you are going to mention funeral arrangements, although you don't have to, you can do that separately. You're going to appoint a personal representative. That should be someone in your life that you know who is the most organized and who can take on the task of figuring out what assets there are and then distributing them according to what the will says. The other part that a will does is it names your beneficiaries. Who are the people that you want to receive what you've worked so hard for? Do you want it to go to just totally to a spouse? Do you want to set aside something for charity? Do you want to make sure there's contingency in place? So maybe you've named 3 beneficiaries, but what happens if they pass? Where would the money go after them? So that's the opportunity to really plan thoroughly so you can determine and put in place how you want your assets distributed. So those are the most important aspects of the will. The second document is a financial power of attorney. Personally, I feel like this document doesn't get the credit it deserves. It is such an important document during lifetime. There's all kinds of problems when it's missing. A financial power of attorney, in that document, it's used during your life, only during your life. On death, it could be tossed out. It doesn't matter anymore. In that document, you're going to appoint someone, hopefully that you trust, an agent, okay? It could be an adult child, relative, friend. It could be a professional. That's going to be someone who is going to step into your shoes and manage your money if you are not able to. So it's a very, very important document, and a well-crafted one is going to make sure everything is well taken care of for you. The third document is the healthcare directive. That's a document relevant only during life, and it's going to appoint someone to make this healthcare decisions for you when you're not able to. It's really important. Okay, a couple of other things that the estate plan does, like I mentioned, the life estate deed. Great way if you've got, for example, adult children, you like the house to pass to them and avoid probate, you can have the deed drafted that you still retain full power and ownership over the home, but upon death, it's going to pass to the remainder, meaning whoever you appoint. Let's say your adult children, okay? You retain a life estate, but you enjoy all the privileges of ownership still at that point. Also, In the will, you can direct personal property. That's one aspect that's important too. If you've got special pieces of jewelry, or you've got collections that you've accrued over the years, you want it to go to an individual, you don't want anyone to fight about it, that would be put in the will as well. I've already talked a little bit about beneficiary designations. They're really important. And that's going to be in the will. And then the guardian designation would be in the financial power of attorney. Hopefully that would not be needed, but in the off chance it is, in that document, it's going to name who you would appoint for your guardian. Next. Okay, the will. I've probably covered a lot of this. I don't have to go over too much of it again. Like I mentioned, it's going to direct distribution of assets. It's going to appoint your personal representative. It's going to name the guardian of your children if you've got minor children. It's going to name your beneficiaries. Now, the one aspect I haven't covered yet is that within a will, you can actually put language for what's called a testamentary trust, meaning the trust becomes effective upon death. This is a really good planning tool, especially if you have someone in your family with special needs and you don't want them to inherit outright. If they inherit outright, it can knock them off of whatever government benefits they're receiving. So you want to put in your will a testamentary trust that says this money, X amount of money, this percent of money is going to go to my disabled nephew. And this is going to be the name of the trust. And here are all the terms of the trust. All right, so on death, whoever picks that document up is going to know exactly what to do, hopefully, or they can call me or another attorney. Next. Okay, a revocable trust. I get a lot of phone calls about revocable trusts, and clients ask about them very often. I have to say that for the most part, in simple estate planning, you don't need one. There are ways to make assets transfer outside of probate without a revocable trust. I like to do that for clients if I can, but I'm going to go through it anyway so that way you have an understanding of what it is. A revocable trust is a document, and it's usually got, and it depends on what lawyer you see, it can have anywhere between 10 pages or 50 pages, and it's going to have all kinds of terms inside of it. And it's going to give all the ways that whatever that asset is should be governed. So the benefits of a trust agreement is it is a centralized asset management tool. If all of your assets have the name of your trust on it, and it's no longer just in your name, but it is titled to the trust, then the trust document controls those assets, okay? It could be a great tool to avoid probate, but it's not always necessary, like I mentioned. It does provide for succession of management, and what that means is normally the way it's written is that you coming to me, you're going to be in control. You're going to be the trustee, okay? But whenever the time comes where you can't be the trustee anymore, maybe you've gone through a spell of illness, there's capacity issues, there is a backup, and the backup can now manage your assets according to the trust. So there is flexibility in it. Now, like I mentioned, it also avoids probate, but it must be funded. So I've already sort of hinted towards that by saying that whatever asset you have has to have the name of the trust on it and not your individual name. Very important. You can have a trust document, stack of paper, but it will do nothing with your assets unless your asset has the name of the trust on it, okay? So there are other benefits to the trust. It could protect vulnerable beneficiaries. There's spendthrift provisions. That has to do with protection of people from creditors. And there's estate tax reduction sometimes with married couples. Now, what it does not do, and I get this question a lot, is that it does not protect assets if someone is in need of the Medicaid long-term care benefit. It will not shelter those assets. They are considered completely available. Next. Trustees. So I've mentioned the trust. I said that you're probably going to be the trustee, which is usually always the case in a revocable trust. But you're definitely going to want to name successor trustees. So it could be a family member. That's usually who it is. If you don't have a family member that you trust, or you don't want to bother your family, friends, it can also be a professional, such as an attorney or another fiduciary, or it can be an institution, which I know of a few that do that. Next. Beneficiaries. So the most common beneficiaries in your estate planning are going to be adult children, charities, disabled family, other family members. Next. If you have a trust, okay, is it funded? It's like I mentioned before, it must be funded. Definition of that, the most simplest definition, your assets must have the name of the trust and not your individual name. So what happens if maybe there's an asset you forgot to retitle after we've done your trust? Something got, something was just completely forgotten about. Well, then what we have is during our estate planning session, I draft what's called a pour over will. That will catch anything that is not properly funded to the trust. And basically it creates a loop. The trust is the first document we look at. If there are assets that are not funded to the trust, then we look at the will, and the will says, bring those assets back to the trust, and it's distributed according to the trust. Next. Okay, so segueing now away from the will and the possible trust, if it's necessary, is the financial power of attorney. Like I mentioned, the most underestimated document ever, I feel like. It is not a document that should be downloaded online. I've often had clients come to me with those documents, and I've had to untangle the problems, and it's cost more money. I'm happy to do it, but it costs the family more money. So financial powers of attorney deal with money. That is their primary purpose. You appoint someone to manage your money if you're not able to. And this is important too. Just because someone is the agent that is appointed under your power of attorney doesn't mean that they have all powers under the sun. It's only going to be those powers that are listed in that document. That's very important. Okay, a well-drafted power of attorney can do wonders when it's really necessary. Now, if you have a revocable trust, sometimes people think, well, I don't really need a financial power of attorney because the trust kind of does everything and beyond. But the financial power of attorney is still relevant because it will apply to any of those assets that were not captured by that trust. Also within the power of attorney, it can nominate a guardian, meaning if you need someone to step in entirely and make all decisions for you on your person, based on like where you live and your assets, a guardianship can come into play. I draft my powers of attorney so that hopefully that is never needed. I like to do the simplest things for clients as possible. Next. So practice tip, beware of adding a family member to your bank account. This is a very common thing that I see with older adults and their adult children. They will actually put their child's name on the bank account as a joint owner. I usually warn my clients against this, and this is the reason why. If you have more than one child, you've basically just given all your money to the one. If you have 5 children and one of them is on that account with you and your spouse, they are entitled to that money in the same way that you and your spouse are. Okay. On death of each spouse or the individual adults, that is, doesn't have to be, could be a widow with an adult child. On the death of the married couple or the mom or the dad, that child that is named on that account that money goes directly to them. They have no legal obligation to share that money with their siblings. So it can really undo any estate planning that you may have had in mind or have done. The other issue is I have had clients come to me where the adult children have taken money. Thankfully, I feel like it doesn't happen that often, but it happens enough where I feel like it has to be a warning point. The better practice is to have a financial power of attorney, and that person, whoever you choose, can manage your money, can manage your bank account. They'll be listed on the bank account as a power of attorney, but they're not entitled to that money. They have to use that money for your benefit. They have to use it for you. They're under fiduciary responsibility to not misappropriate it. But just outright putting an adult child on a bank account can lead to problems. Next. Okay, we've covered the will, we've covered a trust if it's necessary, we've covered the financial power of attorney. Now that third document, the healthcare power of attorney. This handles health. It's going to name someone who's going to make healthcare decisions for you in case you're not able to. What's really good about the document is it specifies your care. Maybe there are situations that a person can find themselves in, and they're not going to want certain treatments. They're going to want that turned down. It should be in writing. Or maybe you do want those treatments and nobody knows it. It should be in writing, and this is the document to do it. Also in this document provides a HIPAA authorization, which is very useful to talk to doctors, to access medical records. Next. So that's sort of the overview of the estate planning. And I kind of wanted to tie in because this is Dementia-Friendly America. And we want to sort of, we want to consider how do we have these conversations maybe with a family member that might be experiencing dementia. Maybe it's in the early stages, and there's concern that nothing is organized yet in terms of assets. There's no legal documents. What are we going to do? And it could be a really hard conversation to have. And I'll use just the example of a married spouse. You know, maybe husband sees changes in wife, and it's a delicate conversation. It's not an easy one to have. So I just wanted to give some recommendations about maybe how the conversation can be approached. One way is to sort of consider what's happened in the last couple of years with COVID. The conversation can be broached in terms of, you know, the last few years have showed that there's a lot of uncertainty, unexpected health issues that just kind of came out of nowhere, and our lives have been sort of upended. That maybe now's the time we should consider getting some legal documents in place. What do you think? Maybe we should both go to the doctor, get a full review. Just maybe we haven't had one in a while, and let's just do this and get checked out, and think about talking to a lawyer and getting these documents in place. So you can broach the conversation gently. One way to do it too is to say, sort of try not to say, you know, I've noticed with you, you know, or you're doing this, or I wish you would stop doing X. Maybe it can be more like, I would want to know if you see changes with me. You know, I'm kind of worried. Dementia is sort of a big thing. It happens to a lot of people. Maybe you can even bring into the conversation people that you've known that have experienced this and what's gone with the family. So I want, you know, if you see any change with me, maybe you can let me know. And what would you want me to do if I see it in you? So that could be another possibility to bring up the conversation. Another good sort of visual, and you can do this out on paper, is what I've referred to as a conversation tree. So think of the topic, and maybe it's like the memory loss that you've noticed in your loved one. Think of the questions maybe you can ask to kind of sort of gently prod, like, we got to get our affairs in order, or we need to get to a doctor and see, you know, what we can do. So think of the questions, and then think of possible responses and objections, because there is sometimes some defensiveness when these topics are broached. You can think of responses and constructive ones of yours to keep the conversation on track and avoid argument. And the purpose of this exercise is really just to build a supply of compassionate and persuasive ideas, to try and bring your family member to this point of, taking a look at the changes that are going on and, what steps can we take? And, it's definitely in mind to not control or command the conversation, but, developing the conversation. And you can practice this with other family members. You can write it out in the conversation tree. You can sort of like go over it in your mind, broach it with your loved one. It doesn't have to be perfect. If you forget some points, it's not a big deal. And maybe the first conversation doesn't go great. You can take a break. You can try again. I like to think of it as like sometimes a series of small conversations that you're just kind of gradually approaching about what can you do to tackle this subject and maybe just kind of put affairs in order before you get to the point of needing to call the ambulance, because you don't want to wait until that point. So that's pretty much my spiel, and I'm happy to answer questions. I also specialize in Medicaid long-term care planning. So any questions related to Medicaid and qualifying for the benefit, I'm also happy to answer. I always like to leave lots of opportunity for people to ask what may be on their mind.